Welcome to Law Sessions. I'm Jennifer Housen. Today we'll be using the Irac method to tackle a land law problem, in particular one about easements. Now the case study is about Art and Ben, and the key issues are 1. Whether Art has an enforceable right-of-way over Ben's property, and also 2. How far that right might extend. Now, before we jump into the actual case study, let's remind ourselves of Irac. The first thing you want to do is identify the issue. What is the legal question? Then you need to state the rule, meaning you need to state the relevant law or authorities like the case law. You then move on to the application where you apply the law to the facts, and finally you give a conclusion, meaning a clear outcome. Using this structure will help us to stay disciplined and also help us to stay exam ready. So now let's have a look at the facts. Right. Art is the fee simple owner of the adjoining properties Orangeville and Guavacot. Access to the main road from Orangeville is across an uneven open field overgrown with thick grass, or along a paved path which runs through Guavacot's garden. Art lived at Orangeville. Guavacot was unoccupied until 2004 when Art sold it to Ben. At that time, Ben gave Art permission to continue to use the paved path in order to reach the main road. Ben also agreed to erect and maintain a fence between Orangeville and Guavacot, leaving an opening as access to the paved path. In 2009, when Art converted his house into a guest house, he bought a minibus and 10 cars to transport his guests, with a consequent increase of vehicular and pedestrian traffic on the paved path across Guavacot's garden. Art complained to Ben that the fence had fallen into disrepair. Instead of repairing the fence, Ben blocked the entrance to the path so that Art could not drive his guests across Guavacot to the main road. Advise Art. Okay. Now you've seen the case study for Art and Ben, and if you wish to simply get the answer, you can do that. Simply scan the QR code, and that will take you to my school community, navigate to resources, and you can get the answer plan. However, I would ask you to stick with me so we actually go through this and we can then look at the answer plan in detail by going through the process of Irac. The first question is whether Art has an easement of a right-of-way over Guavacot. Is his right a legal easement, or is it that he only has a personal license? There are some sub-issues here. And the first, of course, is was a legal easement created in 2004? If not, could there be an equitable easement? Or are we looking at a license, or are we looking at a estoppel? Does the guest house traffic exceed any easement scope? And is Ben obliged to maintain the fence? Finally, can Ben lawfully block the path? These are the questions we have to navigate as we approach Irac. So the first is issues. These are the issues we need to look at. So we've narrowed down the issues, which is the I in Irac. Let's move to the R, the rule. Easements can be created in 4 main ways: by express grant or reservation, which must be by deed under Section 52 of the Law of Property Act 1925. It can be by equitable methods, such as proprietary estoppel, as in the case of Crabbe and Arran District Council. It can be created by implication, through necessity or common intention, under the rule in Wealden and Burroughs, or under Section 62 Law of Property Act. Finally, it can be by prescription, where the use has been long enough, usually 20 years as of right. So the first thing is to determine, as it relates to the rule, creation. Was it created under any of the legally recognized ways of creation of an easement? Now, still staying with rule, what is an easement? Well, the classic test comes from Reilenborough Park. An easement, it says, requires four things. First, a dominant and servient tenement. Second, the right must accommodate the dominant land. Third, there must be diversity, separate ownership and occupation. And fourth, the right must be capable of forming the subject matter of a grant. These are the starting tests for you to determine whether or not there has been an easement. So we look at creation of an easement, we look at what is an easement, because these are the rules which we are going to need to apply when we come to that juncture of the Irac framework. Okay, the last thing we're looking at as it relates to rules, we look at the scope and use. So the scope of an easement is limited. It cannot be radically widened, and this is seen in the case of Wong and Beaumont. Now, if there is intensification, it may be acceptable if it is consistent with the original purpose of the easement, and that's macadam's homes. But if there is excessive commercial use that is not allowed, Gilbert and Davis tells us that. And finally, if the servient owner generally does have no duty to maintain an easement, and this has been confirmed in the case of Regis Property and Redmond in 1956. So the question then in applying is, was there an express easement in 2004? What we see is Ben had given Art permission to use the path, but there was no deed. That makes it a license, not a legal easement. The fence agreement was personal, it was not proprietary, and therefore there is no legal right. So the question is then, could an easement have been implied? And we are in the era of application now, right? The A of Irac. Well, necessity fails since Orangeville still has field access. Common intention fails too because a gestalt wasn't contemplated in 2004. Wealden and Section 62 also fail because the right only arose after the sale. So there's no implied easement. Prescription requires 20 years use openly and as of right. So here, Art had only used the path for 2 years before the dispute, and that is too short. So there's no prescriptive easement, and prescription also fails. Okay, we're still in application because we're still applying the rules to the issues that we have. Now, could Art rely on estoppel? Well, he clearly relied on using the path, and he suffered a detriment by adapting his property and his business. In the case of Crabb and Aaron District Council, there was a similar reliance which led the court to find an equitable right. So there may be an estoppel-based claim here because everything else we're looking at in relation to creation of the easement is not being met. Okay, what about application as it relates to blocking the access? Well, if this is only a license, Ben could revoke it at will, and blocking the path would of course be lawful. But if it is a legal or equitable easement which existed, then blocking the path would be unlawful. It would be an unlawful interference. Now, an estoppel easement could make blocking actionable, and that, of course, depends on the court recognizing Art's reliance, detrimental reliance in the entire scheme of things. Okay, let's press on to the conclusions here. We're going to start with the existence. Now, there is no legal easement, and I would certainly suggest that you argue that. Why? Because in examiner speak, when you see a land law question, the kind of word that examiners use to show that something has been a legal transfer will be conveyance. Once you see conveyance or conveyed to, then that's kind of like examiner speak for that. Here we're told that it is sold. So honestly, you could argue that there's no legal easement because there's no deed. You then would, of course, need to move on to say that the strongest claim is potentially proprietary estoppel, and success, of course, would depend on whether there was increased commercial usage, which was foreseeable. If not, there's a license we would find which is not binding, may well be revoked, and once it is revoked, the license is not binding on revocation. So, arguably, Ben has no easement, only a license. No legal easement means that it is only a personal right, which can, of course, be revoked at will. So, overall, what can we conclude? Well, again, in suggesting an outcome, art appears to have no legal easement in the absence of the deed, as I said. His strongest claim appears to be via proprietary estoppel, based on a reliance and detriment finding, but actual success will depend on whether the commercial intensification was in fact foreseeable. Otherwise, he's left with only a revocable license. Even if we get over the hurdle and we say that an easement could be argued, the guest house use may arguably still be excessive and the scope is breached. Now, there is no duty on Ben to repair the fence. He is a servient owner. Ben would then be entitled to block the path. At best, if estoppel is proven, Art may gain an equitable easement and be able to sue for damages. Otherwise, worst case scenario, he may have to fall back on the field access. Okay, well, we've come to the takeaways for exam, and we go back to where we started, which let's recap Irac. The first thing is the issue. Issue is does Art have an easement, and what is the scope of that easement if he does? Rule. Well, the rules here are first, Raillinborough Park, next, looking at the methods of creation of an easement, next, looking at estoppel, and of course, the scope limits of an easement. How do we apply? Apply. Well, we need to ensure that we set out that a license is not an easement. On the facts, we're not seeing an implied or prescriptive right. We're seeing the intensification. We're seeing that excessive use. We're looking at potentially an arguable estoppel claim. And lastly, for conclusion, the outcome here is that potentially Art's claim is weak. Ben is likely to succeed, as harsh as it may seem. But the exam tip that you must walk away with is you always start with Raillinborough Park. It's an easement, okay? Then you check the creation. Is it express? Is it implied? Is it estoppel? Is it prescription? And then once you've done that, you want to then set out your outcome by the way you have applied. Hopefully that gives you some idea of how to approach this sort of question. Okay, that's it from me. And now that we have actually gone through the entire Irac of that question, you may now, of course, scan this QR code. It will take you into my school community. You navigate to the resources and you will be able to get the answer. The answer plan is only a suggestion. Please bear in mind that if you use a different sort of application, you must get the rule right. You must get the issue right. So you can't sort of saying, this is a mortgage. It's not. It is about easement. So you need to spot that issue. You need to look at the role, Raillinborough Park, how you create an easement, and whether or not an easement appears to be found on the facts. But how you apply is what will give you your conclusion. So do bear that in mind. So hopefully I will see you in the community. If not, please look out for the next land law Irac question that I will present. Thank you very much.